Hello friends, New York divorce and family law attorney Bryan Hutchinson here. Today's topic is how to protect yourself if you get married later in life or you have children from a prior relationship. Now, if you're going to get married, you're in your 50s or in your 40s, 60s, you should have a prenuptial agreement. Because you want to make it crystal clear what assets you're coming into the relationship with, and that these assets are your separate property, and after the marriage they will remain your separate property. Any appreciation in your separate property will continue to be your separate property. So you should get a prenuptial agreement. Now, one of the mistakes that people make in doing prenuptial agreements is that they wait until 2 or 3 months before the marriage to get the other party to do the prenup. You should do it at least, I would say, 6 months before you get married. And the reason you want to do that is that you want to avoid someone later on in life saying, well, I entered into this prenuptial agreement under duress, undue influence, or force, or trickery. I was pressured into doing it. Okay, that's mistake number one you want to avoid, is to doing it at the last minute. Mistake number two is not being transparent. You must be transparent. You must have complete disclosure. That means you must disclose all your assets, all your liabilities, and you must disclose your income. Because you don't want a court at some point to say, well, you are making $250,000 a year and your new spouse was making $50,000, and they didn't know. If they knew, they would have asked that a provision for spousal maintenance be included in the provision, and the court set aside that provision. So you want to do your prenuptial agreement way in advance, at a minimum 6 months, and you want to have complete disclosure. Mistake number three to avoid is failing to have your spouse sign the appropriate waiver. Now, I said spouse because after you're married, if you have pension and retirement benefit plans that are governed by ERISA, you need to have your spouse sign a waiver of any rights or interests in the pension and retirement benefits. No, ERISA doesn't say fiance, it says spouse. So that's why after you get married, you have to have your spouse sign the appropriate waiver. Now, assume you're madly in love and you're nervous or afraid to ask your spouse to sign a prenup. You can always do a postnuptial agreement, and it requires essentially the same disclosures and signing of the waiver. So make sure you either have a prenup. If you didn't get an opportunity to do a prenup, you could always do a postnuptial agreement. Now, if this person is going to say to you, oh my God, you don't trust me? No, it's not I don't trust you. It's that I want to preserve these assets that I accumulated prior to our marriage for my children from my previous relationship, or to protect these assets which we didn't create together. It's about fairness and what's equitable. Okay? Now, just because you have a prenup or a postnup is not complete. In order to protect your asset in the event of your demise, you should combine that with some trust and estate planning. Say, for example, you have a house that you had real property before your marriage. You want to create a trust, and you want to transfer the house to this trust, and you want to open up a separate account for the trust where the mortgage and the carrying charges for this separate property will be paid from this trust checking account. Because you want to make sure that any appreciation in this house is going to be paid out of this trust account. You already agree and acknowledge in this prenup or postnuptial agreement, you want to have 3 accounts. You want to have account for wife, account for husband, and you want to have an account for joint household bills. Well, if you have, for example, real property from a separate relationship or prior to the marriage, you want to title that put it in the trust and open up a bank for the trust account and have those carrying charges for that property paid out of that trust. Okay, now you also want to avoid DIY forms on the internet, because there's lots of things that you're not going to know that should be in an agreement. You know, one of the most dangerous thing I come across is a client who's highly intelligent, very sophisticated, but the problem is they don't know what they don't know. So you want to be careful. Another thing you should also do is you want to have a power of attorney. And the person who should have that power of attorney should be your children from this prior relationship, or someone who's trustworthy, your lawyer, your accountant, the brother, sister, because you don't want later on in life, if you should become incapacitated and can't manage your financial affairs, that this new spouse uses the power of attorney to deplete your separate property, checking account, bank account, and so forth, to pay for certain bills that shouldn't be paid from your separate property account, because you want them to use the joint account, the joint marital account, to pay bills that are marital bills. So this is just a few tips on how to protect yourself if you're getting married late in life, or this is your second marriage, or you have children from a prior relationship. If you like this video, give us a like, subscribe to this YouTube channel. Thank you very much.